Hi, everybody. I'm Samantha from the law offices of Samantha Wolfe, and we're located at 20 East 6th Street, Suite 206. We're located in Waynesboro, PA, and you can reach us at 717-655-2676. Thank you all for being on today's virtual seminar. I'd like to welcome you today. I know it's the day after Valentine's Day, so I hope that you all had a day where you could celebrate those that you love yesterday. My nephew came in and had lunch with me yesterday and brought me some wonderful pink carnations. So it was a good time over lunch. So, all right, let's get started on today's seminar. I'm going to go ahead and share my screen. Okay, so let's jump into today. So we always like to start off with our mission statement. So we really do want to make sure that we're adhering to this. It's important to us that our clients know that we want to provide education for them. You can always check out our YouTube channel, our website. It'll direct you to our YouTube channel. We have all kinds of videos there for you to check out. So today we're going to talk about a love letter to your family, how to leave a legacy without hassle. So we've been doing these virtual seminars once a month since we opened the office in July of 2020. And so as you can imagine, we're almost, a year and a half, almost inching towards 2 years of doing monthly virtual seminars. And so I feel like a lot of the information that I can just speak at you, it might be helpful to give you some examples that show some real life situations. We don't use any client names, but we base it on client situations that we've had here in the office and show you some ways that we've been able to help with our clients' estate plan. So that's what we're going to do today. And we're doing it in the context that we just came off of Valentine's Day, and the best way that you can show your loved ones and your family how much you love and care for them is to have a great estate plan in order, because it really does make their lives easier if something should happen to you. So with that being said, let's jump right in. Like I said, happy Valentine's Day to everybody. Just generally, before we jump in, I just have a few slides. So when we're talking about asset protection and leaving a legacy, who needs to do that? And so we have a whole list of people: physicians, CPAs, attorneys, financial planners, insurance agents, business owners, property owners. So anybody who's on this virtual seminar, you would fall under at least one of those categories. So we're talking about leaving a lasting legacy or for your family. We're talking to you and to those in your family. What does your family need protection from? So it could be that you're looking at the next generation when we want to protect against divorce. We want to protect against somebody passing away and the estate plan being fulfilled the way you want it to. So we're going to talk about that as we leave a lasting legacy. Talk about protection against debt. We're going to talk about protection against nursing homes. And this could be for you, for the beneficiary, or for both. So our goal here is that when we're designing an estate plan or some type of legacy plan for our clients, we want to make sure that we're not only looking at our clients, but if it's important to them to make sure that their beneficiaries are protected, we want to make sure we're doing that as well. So what is an asset protection plan? For those of you who have been on our previous virtual seminars, this is a slide that should look familiar to you. We just recycled it because we felt like this information is so important. So an asset protection plan is really a plan designed to help clients protect wealth and assets from creditors. And that could be creditors, like I said, related to yourself as well as your family members. We also want to do a plan that positions the client in the best tax structure to minimize taxes. And we have one of our examples that's targeted for income tax planning, because what we're seeing is income tax planning is important to more and more people. So how can we make sure that when we're coming up with an asset protection plan and a legacy plan for a family, how can we make sure that we're minimizing not just inheritance taxes and federal estate taxes, but also income taxes? So we're going to talk about that in one of our examples. We're also going to talk about how it's important to shield those in our lives, our loved ones, from any potential creditors they would have. And then we want to make sure that we're protecting future generations, children, grandchildren, on down the line from any creditors they may have. But we also want to balance that with placing control in the hands of our clients, as well as those trusted individuals when it passes to that next generation. So that's what we're going to talk about today. These are all the different things that you might need to protect. So you might need to protect children, your primary residence, any vehicles, so automobiles, as well as we've done airplanes, boats, vacation rental properties where you have tenants, in-laws. So if you have a child who has a spouse, you might want to protect it against any in-laws. And then we might want to protect grandchildren as well. And then why are we doing this? And that's because people might be underinsured. They might be excluded from any type of liability policy. The insurance company might go out of business, or there might be premiums that have increased. I was on the phone yesterday with someone who had insurance and they saw 113% increase in the premium from last year to this year. And we're seeing that across the board, whether it be for long-term care insurance as well as for different liability insurances. So these are all different reasons why you want to make sure that you have your asset protection plan in place. So with that being said, we really want to focus on how can you create your own protection. And the way in which we're going to approach this is we've come up with a couple of situations and we've tried to throw in examples that we've seen from our clients' lives and tried to create real life scenarios so that you can see what we're able to do at our office to help protect our clients and to help them have that legacy that they've always wanted. And we're going to talk about that in the context of trust. So there are all different kinds of trusts that we can use as part of our estate plan, and we're going to go over them. We even have an example with a charitable trust. So I know that you're all going to be really excited about that. Okay, so situation number one, we have Craig and Michelle, husband and wife. They've been married for 40 years. They're in their early 60s. They have two children, Jack and Jill. Both children are happily married and they're financially secure. And so we're going to talk about how do we go about creating a lasting legacy for them. The concern that they're most worried about is long-term care. So how do we make sure that for them, that we're protecting them against long-term care costs? We're going to talk about that for them. And again, there's going to be examples that will fit anybody here on the call. So just hang tight if this isn't a situation that applies to you. So with that being said, let's take a look at some of their assets. So for those of you who've been through the process at our office, a lot of times we'll ask for you to complete an intake form. And it's a sheet that we've put together here at our office that asks for spellings of people's names, addresses, who are those emergency contacts, but it also asks for asset information. And sometimes clients are hesitant to give us asset information. And one of the things I wanted to start off with this example is explain why that asset information is important. So the first reason to know is that certain assets aren't going to pass through your last will and testament. So when we're creating a legacy plan or an asset protection plan, it's important for us to know what assets you have that could possibly be transferred not through your will, but through a beneficiary designation. So retirement accounts are a great example of that. You have the ability to designate beneficiaries on those retirement plans. So if you've designated a beneficiary, then those accounts or those funds aren't going to pass through your last will and testament. So we could go through all the trouble, time, and expense to create a will that distributes assets the way you want. But if you have a retirement account that you can designate a beneficiary, that's gonna go separate from your will. So we have to make sure that we're coordinating the estate plan, not just with those assets that would pass through the will, but also those assets that would go via beneficiary designation. So that's why we ask for certain assets. The other reason we ask for it is that when we can see your assets, and we also have like a checklist where you prioritize what's important to you or what your concerns are. And what we're able to do is reconcile the concerns with what assets you have. So if you have a concern about long-term care costs, like Craig and Michelle in this example, we can look at your assets and say, these are the assets that are going to be available for long-term care costs, and these are the assets that we can help protect, and this is how we can protect them. And know that when we're talking about protection, it could be investment products, insurances, those type of things that we work in conjunction with your financial planner. It can also be using trusts. And so the focus of today's presentation is how do we use trusts to resolve some of these estate planning questions that we have our clients bring to us. So here we have Craig and Michelle. So this is what they would have filled out their asset intake sheet to let us know. So usually we ask, what is the assets? We have a primary residence. We're going to ask for the best guess of what you think that value is. So they think it's $350,000. Then we're going to ask how it's titled. And so in this case, it's titled jointly with husband and wife. The reason why that's important is that if it's jointly titled between husband and wife or between the client and someone else, when they pass away, it could be that based on that joint ownership, it doesn't go through the will either. So the best example is husband and wife, where husband and wife's names both on the deed. So if husband dies, it automatically goes to wife. If wife dies, it automatically goes to husband without having to do a new deed. So that's why we ask how things are titled, so that we can determine, is this something that's going to go through the will, or again, does it go to a joint owner? The last column we have is just, what are we planning to do with it? Are we transferring it? Are we designating something as the beneficiary other than who the client has as individuals? Or if they have the estate, do we want to update those beneficiary designations to be individuals? Then we have two vehicles jointly titled. I get the question a lot about, should our vehicles be jointly titled? And does it make it easier when one of us passes away? So know from our experience in Pennsylvania, especially between spouses, that if it's only in, let's say it was just in Craig's name for this example, if you take a copy of the death certificate to a title and tag and title transfer place, then you can actually transfer it to the spouse. So in this case, Michelle, she could transfer it as long as she has a death certificate, and she can transfer it to herself. So a lot of times it's more of a question of liability protection. So if it's just in Craig's name and Craig is sued for something, let's say that he has a rental property and somebody gets injured, so somebody's suing him. If it's jointly titled, then they can't touch that vehicle. If it's jointly titled, then they can. Same thing where if we're talking about a car accident where you're in an accident in that vehicle, it's all about, well, how was it titled and who was the insured? So that tends to be the more important question dealing with husband and wife and how it's titled. I'm not really overly concerned whether those vehicles are jointly titled or whether it's just in one spouse's name, because again, here in our experience, you don't typically have to probate if you're just trying to transfer a vehicle to the surviving spouse. In this example, Craig and Michelle also have $15,000 in a bank account that's jointly titled. And again, that's important because if one of them passes away, it doesn't go through the will. By law, automatically goes to that joint owner or that spouse. Then we have our retirement account. Wife has $650,000 and husband has $500,000. So we have a total combined estate of $1.5 million. That's important because it does let us know, do we have any federal estate tax planning concerns? Right now, the exemption is up to 12 million. So together, it's quite significant there. It would actually be $24 million that you could pass as husband and wife. Individual, it's 12 million. So we saw that up from 11.7 million from 2021. So in this case, Craig and Michelle, we don't have to worry about federal estate tax planning concerns. The only tax that we have to worry about when one of them passes away, the only death tax, would be Pennsylvania inheritance tax. And if everything goes to spouse, there's a 0% tax. It would be if it goes to children, then there would be a 4.5% tax at that time. So when we're talking about, remember, their concern is long-term care. So what they want to do is their goal is to create a legacy plan that they're protecting assets against long-term care costs. So how do we do that for Craig and Michelle? So we're going to take a look here at their visual. So we're able to use trusts to do that. So what we can do is we can create a trust that would own their primary residence. You see that one on the right. Craig and Michelle, they would be the trustee. We have Jack and Jill as the successor trustee. Jack and Jill are also the trust protector. When we're talking about a trust protector, know that in Pennsylvania, if you transfer assets into an irrevocable trust with the intent or with the goal to get long-term care protection, you yourself can't reach in and pull out those assets. We have to have somebody else to do that. Now, Jack and Jill, as their kids, we can appoint them, and we can appoint them in the role of trust protector. So how that looks is that if Craig and Michelle want to sell the property as trustee, they can do that. If they want to invest the funds, they can do that. They can buy, sell, they can do anything they want as long as the assets stay inside the trust. If they need to withdraw those assets, and in this case, when we're talking about a primary residence, we typically only see that in two instances. And that's if somebody wants to take a lump sum out. Usually it's something like buying a car that you don't want to be owned in the trust, or it might need to go on a nice vacation. Those are the two most common examples. And in that case, what Craig and Michelle would have to do is if they sold their primary residence, remember we have a primary residence for $350,000. So if they sold that and downsized and maybe bought a house for $200,000, they would have $150,000 left over. They can choose to invest that in stocks, bonds, buy insurance, whatever they want, as long as it's in the trust. Craig and Michelle decide that they want to take out $20,000. Maybe they want to buy a new car and they want to do it all at once. Then they would just have to have Jack and Jill reach in to the trust and pull those assets out, that $20,000 out. Now, if Jack and Jill decline and say no, that they're not going to do that, then Craig and Michelle do have the ability to fire them from the position of trust protector. So it's a great way to protect assets against long-term care costs if it's things like real estate, where it's highly unlikely that we're going to need those funds back out of the trust. Or even if we do, if we have a situation where we have trustworthy children that can help us pull that out. Now, know that the primary residence is an exempt asset from long-term care costs. So when we go back here and we look at what assets they have, the primary residence is exempt if one of them needs long-term care costs, meaning that a nursing home can't force the sale of the primary residence to pay for one spouse's long-term care. But the reason why we still recommend a trust for the primary residence is because if somebody passes away while they're receiving Medicaid benefits in a nursing home, then the Department of Human Services can come back and recover against it. We call that a Medicaid recovery lien. So that's why sometimes we put the primary residence in there, because what we can do is we can guarantee then that the value of the primary residence is going to be there for the spouse. Because let's say he only needs assisted living level care, and Michelle's the one who needs long-term care, nursing home protection, or in-home benefits that rise to skilled level. The benefit here is that if we put the primary residence in the trust, then the primary residence can be sold, which if it wasn't in the trust would make those funds immediately available for care. In this case, they could stay inside the trust and be used for the spouse that doesn't need skilled level care, that mainly need assisted living or personal care. So that's why we usually recommend putting a trust, having the trust own any primary residence if long-term care costs are a concern. All right, so let's move forward here. Before we leave this slide, let me say that the retirement accounts, if Craig needs long-term care, his retirement account is available to pay for his care, but Michelle's retirement is not available to pay for his care. And so in this case, what we really need to do is we need to protect the house. And you're going to see in this example, we do have a trust that would be designated as the primary beneficiary for the retirement, because in our example, if Craig needs long-term care, his retirement is available for his care, but it's not available, or Michelle's retirement is not available for Craig's care. But if one of them passes away, if Michelle passes away and Craig is the primary beneficiary, we took an asset that wasn't initially available to Craig's long-term care and we made it available all at once. So typically what we do is we recommend that we update the beneficiary designation to be the trust as the primary. What that means is that when Michelle dies, if Craig is in a nursing home, the retirement is paid into the trust. If when Michelle dies, Craig is not in a nursing home, remember he is the trustee of the trust. He can exercise a disclaimer, which means he can say, I don't want the funds to pay into the trust, and then he can receive them outright. So it's a great way that, when we don't know who's going to need long-term care, what order people are going to die in, this is just allowing us the flexibility to say, we're going to wait and see when that event actually happens and what we need to do. It's a great post-mortem technique. So this is our example of Craig and Michelle. Remember, their primary goal was long-term care. And so what we were able to do is we were able to protect the value of the house, and then we were able to protect the retirement if when one spouse died, the other was in a nursing home. So this creates a great legacy plan for Craig and Michelle. You are going to see here that Jack and Jill, Craig and Michelle made the decision to have it paid outright to them. We're going to see some examples later on where clients have made different decisions. So that's what that little circle represents, that once the second spouse dies, once both Craig and Michelle pass away, then it pays outright to Jack and Jill. The other important thing to note about this legacy plan is that there's no probate for any of the assets that are transferred into this trust. And that's because probate only applies to assets that go through the will. And so when we go back here to our example of assets, the 2 retirement accounts don't go through the will. The 2 vehicles don't go through the will. And the bank account is jointly owned. So when the first spouse dies, it goes to the surviving spouse. When the second spouse dies, that bank account, to the extent that it exceeds $10,000, it will be subject to probate. But we did take the one asset, the primary residence, that would have been subject to probate, and we've transferred it into a trust. So when the second spouse dies, there's no probate for that primary residence. So that's our situation number 1. Let's go to situation number 2. So I base this off my parents, and I know my mom is listening today, so thanks for being on the call, Mom. So I'm going to use my parents. It's Denny and Denise. And this is a picture of my sisters and I. I would like to point out that my younger sister is the one who has the horrid face there in the front. So I'm quite happy off to the left, kind of smirking there. So I have 3 sisters. I'm one of 4 girls. So let's take my parents' example. Let's say they're both in their early 60s. They've been married for 41 years. They have 4 daughters. 3 of the 4 daughters are married. And again, some of these things I'm adjusting the facts a little bit just so that I can use this as an example. So in this example, let's say they love 2 of their son-in-laws, but they aren't fond of one of them. We also have in the example 1 granddaughter who has special needs. My one sister does have a daughter with special needs. So when I was talking to my parents about their planning, this is something that came up. So I wanted to go over that with you. And then 1 daughter is not married. So out of the 4 of us, I'm unmarried. So that's an important fact because you're going to see my parents' concern. Number 1 is that they don't know the future spouse of their unmarried daughter. Will I get married? Will I not? And if so, will they like the spouse? So that's a concern that they have, especially because they have one son-in-law that they don't like in this example. So, to them, it's something we have to make sure to plan for. The second thing is that their granddaughter has special needs. So we want to make sure that anything that would go to that granddaughter is going to be protected since she does or could potentially qualify for government benefits because of her special needs. The third thing is they don't want son-in-laws to receive any part of the estate if a daughter would predecease. So in our example, again, they have 2 son-in-laws they like, 1 they don't. So, in across the board in all the situations with my sisters who are married, they want to make sure it goes to the grandchildren, that they keep it in the family. And then the last concern they have is long-term care as they age. So know that when we're looking at this, usually people will have, certain concerns. I always ask for their top 3 concerns, but most of the time people have 5, 6, 7 concerns. And so I always like to flesh out what is most important to them when we're trying to figure out what's the best legacy plan that we can do. So let's look at some of these assets here, and you're going to see that some things are a little bit different. I'm using this as an example to try to explain why we make certain recommendations. So let's say in this example, Denny and Denise have a primary residence that is worth $300,000 and is jointly titled, meaning both husband and wife are on the title. We have a bank account with $15,000, and let's just say that that is jointly titled as well. Then we have an investment account with $275,000, which is just in Denise's name, just in wife's name. Then they each have a retirement account. So we see that husband has $150,000, wife has $100,000, and then we see life insurance. So this is one where Denny, the husband, is the insured and the owner. And I put in here that it has a death benefit of $250,000 with a cash value of $87,000. So Denny and Denise have a net worth of a little over $1 million. And you're going to see off to the right on the chart, I already have listed the recommendations. So the first thing to know is that when I'm asking for asset information, I'm always checking to see how it's titled. So that investment account that's just in wife's name, if Denise does not add spouse's name to that or transfer that account to a trust or have a transfer on death or a pay on death designation, then upon her death, her estate would have to be probated in order to transfer that $275,000. So one of the first things that I would do is talk about, is there a reason that this is just in Denise's name? Because we might want to either add Denny's name to the title or to put a transfer on death or a pay on death designation. You're also going to see that when we talk about the concerns that they had, one of the concerns they had was protecting funds against the cost of long-term care. But as you're looking at these assets, again, we know from our last example with Craig and Michelle that the primary residence is something that we can throw into a trust and very easily protect. But when we're talking about an investment account, a lot of times we have to weigh, what does the client feel comfortable with? Because remember, if Denny and Denise put it into trust, they are going to have their trust protectors. And in this case, it would be their kids. The kids are going to have to withdraw anything from that $275,000 if they wanted to pull out some funds from that. So in this case, I might talk to Denny and Denise about only transferring some of their funds to the trust and kind of splitting that investment account. So dividing it, putting husband and wife Denny and Denise's name on the joint one. If let's say we picked 100,000, and then putting the other 175,000 into a trust. So know that there's not an all or nothing with these trusts. It allows you to fund them with what you feel comfortable. So when I'm looking at these lists of assets here, primary residence, although it's exempt, by putting it into a trust, we are able to prevent against a Medicaid recovery lien. We also are able to protect if Denny would go into a nursing home, Denise can rest assured that whether let's say she only needs assisted living level care, we know that $300,000 is going to be protected in that trust if she would need to privately pay, if Denny could qualify for Medicaid for his skilled level. So putting the primary residence in the trust gives us the ability to sell it and still keep those assets exempt from long-term care costs. The bank account, we would just make sure is jointly owned. The investment account, again, when we're looking down through here, it doesn't matter whether it's just in Denise's name or whether it's Denny and Denise's name. This is going to be an available resource for both spouses' care, meaning that if it's just in Denise's name, but Denny needs the long-term care, this investment account would be available for Denny's care. So when we're talking about what assets we want to protect, those are one of the things I want to hit on when we're going through the assets, is that even though it's individually owned, it's still going to be available. The exception to that is retirement account. So when we look at the retirement, if Denny goes into a nursing home, his retirement's available to pay for his care, but Denise's retirement is not available. And then lastly, I want to talk about life insurance, because this is something that comes up that a lot of people don't realize. So if you have a life insurance that has a cash value to it, that cash value is available for long-term care costs. So I know that there's a lot of information. We have some clients who have done irrevocable life insurance trusts. That is something we typically do for federal estate tax planning, but there is the option to use Medicaid trust to protect against long-term care costs and transfer the life insurance policy into that trust to protect the cash value against nursing home costs. So this would be an example of a situation, somebody like my parents, Denny and Denise, that we would recommend that they would set up. So the first thing is that you do need a last will and testament for those non-trust assets. Because remember, everything we transfer into trust or that we can designate a beneficiary, that's going to avoid probate. But we do need to have a will for those assets that are still going to be subject to probate. Second thing is that you can name a guardian for underage children in the will. So we're going to see when we go down through here that in this example with Danny and Denise, they opted to, when both of them pass away, to have each child's share go into trust. But an important thing to remember is that you don't necessarily have to do that. If something would happen to my sister and they wanted it to go to their grandkids, under the will, they could designate a custodian up until those underage grandchildren reach 25. In Pennsylvania, you're allowed to go all the way up to 25. So you can name a guardian of underage children in the will. We also want to add the husband's name to the wife's account. So again, we talked about that investment account that was just in Denise's name. The individual assets are still available for the long-term care costs of the other spouse. We talked about that regardless of how it's titled. The exception to that is the retirement is exempt. But like we saw with the example with Craig and Michelle, when the spouse passes away, if it pays to a surviving spouse and the surviving spouse happens to be in a nursing home, then it does become available. So that's why we're going to recommend trust. We're actually going to recommend the middle trust there to be the primary beneficiary of any retirement accounts, and then name the surviving spouse. In this case, it would be Denise, my mom. She would be named as the contingent beneficiary in that example. So that way she can disclaim if she's not in a nursing home at the time of my dad's death if he would pass away first. Another important thing to remember is that you can include transfer restrictions or distribution rules. So you're going to see that my parents, and I did use my sister and I's names down there, we each have a separate trust, meaning that unlike Craig and Michelle's example where it paid outright, my parents can say, well, no, at the second spouse's death, we do want it to go in trust. Each child has their own trust, and there could be restrictions about when we're allowed to receive distributions, or if, for example, there was a family asset like a family farm, it could say that if one child wants to sell, they have to offer it to the other three. So having it in trust not only protects it for the grandkids. So remember, one of the goals was that if one of the children passed away, that it stayed in the family, meaning it went to the grandchildren. So having it go in trust would ensure that, because if they had it pay outright and one of my sisters passed away, it would go according to their will if they had one. So what this does is it says, no, we're going to keep it kind of in a container where each child can use it for what they want. And then upon their death, anything left over would go to that child's children or grandchildren. And in the case where I don't have children, my parents could say upon her death, we're going to have it go equally to the surviving siblings. The other important thing to know is that designation of a trust for retirement benefits, that does prevent a lump sum distribution. So I just met with an accountant on Friday, and we're dealing with a client where it was an unexpected death, and dad had quite a bit, 900,000 in a retirement account, and the one child is 18, the other's 20. And so the question became, was the trust, because he had set up a trust, was the trust designated as the beneficiary? Because if so, then the children do not have the ability to cash out that retirement all at once. The trustee would be in charge of taking distributions. Post-secure, you can now stretch retirement distributions for a non-spouse beneficiary that's still a designated beneficiary over 10 years. So, and we ran the numbers with this client, and if they stretched out over the 10 years, it would end up saving the beneficiary something like 30% tax, because it wouldn't all be cashed out at once, pushing their adjusted gross income into a higher bracket. So know that that's important too, that you can use trusts to help guide your beneficiaries to do the best tax thing for them. So this is an example of, in the situation that I based off my parents, what this would do. Let's go back over what their goals were. So the first was that the unknown future of their unmarried daughter. So if we fast forward here, and in my case, my share, my 1/4 goes into trust. So upon my death, if there's anything left in there, it would go back to my other sister. So regardless of any potential future spouse I would have in my life, they can be assured that it's going to be protected. Second thing is that if they're worried about my niece, their granddaughter who has special needs, if we go forward here, my sister Krista is the one who has the daughter with special needs. And so what my parents can do is they can say, upon Krista's death, anything that would go to that granddaughter is held in a special needs trust or supplemental needs trust. And so it would allow my niece to be able to qualify for any benefits and still receive her inheritance. So that would be really important. Third thing is that they don't want any son-in-laws to receive any distributions from assets. So again, we see that all 4 children, it would remain in trust. That protects it against any outside influences, whether they like the spouse or not. If it's one of the son-in-laws they like, if my sister passes away and that son-in-law gets remarried, it just prevents from any other influences there and ensures that it's going to stay in the family. And then the last thing was long-term care, protecting its long-term care costs. So again, they would put the primary residence in the trust on the left, the primary residence trust. They would use the income-only trust to be designated as the primary beneficiary for retirement accounts. And then the trust on the far right would own the life insurance, because remember that life insurance has a cash value that's available for long-term care costs. So by transferring ownership of that life insurance policy into the trust, it protects it against long-term care costs. The trust on the far right is not an irrevocable life insurance trust. Instead, it's just an asset protection trust in order to fulfill Denny and Denise's legacy plan. So they can always use an ILIT if they also want to remove it from their federal estate, just a little bit more restrictions in order to be able to do that. In this type of trust, they can still add in and remove the beneficiaries, and they can still change the provisions of the trust. So that's our example number 2. So this plan would have accomplished all of Denny and Denise's goals. and would have made sure that they have a lasting legacy for their future generations. Let's go to situation number 3. So I'm sure everyone can guess what this situation is based off. So we have Mike and Carol Brady, both in their 60s. They were married in 2009. This is important because we just want to know, is it a long-standing marriage when we're making some of these recommendations? Mike is a well-paid physician. Carol's an attorney. This is the second marriage. So we're dealing with a blended family here. Mike has 3 sons, Greg, Peter, and Bobby. Carol has 3 daughters, Marcia, Jan, and Cindy. They both have excellent long-term care policies, and their estate consists of the following assets. We'll go to the next slide to look at that. So notice they don't have any long-term care costs. They have policies that they already purchased way in advance, so we don't need to worry about when we're coming up with a plan. We aren't having to use asset protection trust in order to protect assets in this case. So their concerns are they want to create an estate plan that accounts for their blended families. Wills are going to be problematic in their case. So let me explain why. So even though Mike and Carol Brady have been married for over 10 years, because they got married in 2009, because it's a blended family, if let's say Mike dies first and everything is jointly owned, because remember we talked about how sometimes you do that to avoid probate, to not have to have as much administration costs. So in this case, if Mike died first and everything goes to Carol, when Carol dies, it's her will that governs. So when I meet with Mike and Carol, typically we have a will for each spouse and they're mirror images of each other. So that way, no matter who dies first, we're making sure that their combined estate plan or their combined legacy plan gets satisfied. But what about in the case where Carol gets remarried or Carol decides to change her will? In that case, Mike's already passed away. Carol has every right under the law to be able to change her will. And so she could potentially change her will to cut Mike's 3 sons out completely. And so when we have a situation with a blended family, a lot of times we talk about, especially in a situation where they've blended them and everything's jointly owned, we talk about how do we do this to ensure that both sides are provided for. And I always explain, it doesn't matter to me which spouse it is. We make fun and we say, it's a bimbo clause just in case, somebody would remarry. But this would be whether or not Mike's the surviving spouse or Carol's the surviving spouse. My job as an attorney is to make sure that they're coming in as husband and wife, and I'm representing them to make sure their joint legacy plan is fulfilled. So we're going to talk about that, how we're able to do that. And it's using a different type of trust than what we've talked about in the past. They also want some creditor protection for their kids, and then they want to give 10% of their estate to charity. These are their assets. They have a little bit more wealth than we saw in the previous 2 examples. You're also going to see primary residence. They have a beach house, they have a bank account, and they have an investment account that's all jointly owned, meaning that it's going to be the last man standing. That's how these assets are going to be divided. And then we have retirement accounts. Those retirement accounts will go according to beneficiary designations. So even if, let's say, Mike had listed Carol as the primary beneficiary, know that the rules would be that Carol could roll that over into her IRA, which would allow her to designate new beneficiaries. So again, there's some concern that whoever's the surviving spouse could, and we never want to think that, but they could change the whole estate plan if they would do that. So we have to talk about how do we protect that? Because remember, that was their primary concern, was making sure that their kids are going to get something when they both pass away. So this is an example of the legacy plan that we would create for them. So know that this is a different type of trust. This is a revocable trust, meaning that while Mike and Carol are both living, this trust can be changed. They're the owner. They can pull money in and out. There are no restrictions on what they can do in the assets transferred to this trust. If they set up the trust and they transfer these assets during life, it does avoid probate when the second spouse dies. So that is a benefit of this. When the first spouse dies, this trust does become irrevocable. That's why when we're dealing with a blended family where we want to make sure both sides of the family are provided for, that's why this is such a much better option than a will-based plan, because it's saying that, when one of you passes away, this is it. This is the estate plan. Now, we can always have certain things that we can draft into the trust. If, both spouses decide they want some flexibility, we can do that. But otherwise, what this would do is it would allow everything to stay in trust for the surviving spouse, And then when both spouses passed away, we could have it go in trust to the children in equal percentages. And again, when we go back to what their goals were, it was to account for the blended family, meaning that one spouse couldn't change it once one died. It would allow creditor protection for the kids because we're not having it pay outright, we're having it pay in trust for those kids. So it's going to make sure to protect against any type of creditor they would have, depending on what terms you pick for their trust share. And then the last thing was the gift to charity. So when we're looking up here in the little box, one of the things that we'll talk about is that they do have huge retirement accounts. So when we look at their assets, they have 850,000 and then 650,000 in their retirement. We could, if they wanted their estate plan 10% to go to charity, we could designate a certain percent of their retirement to go to charity. Now, the reason why that's important is that retirement is actually subject to two types of tax when you pass away. It's going to be subject to inheritance tax at a rate of 4.5%. Plus, it's going to be subject to income tax when those beneficiaries draw it down from their retirement. So if we can get an asset that is taxed twice to the beneficiary, if we can get that to charity, the benefit is it frees up the other assets that are only subject to one tax to go to the children. So it maximizes the tax planning and minimizes overall tax. So if they want 10% of their estate to go to charity, then what we have to do is it might be a little bit more than 10% of their retirement because we know their total estate is 2.7 million. So what we would have to do is figure out 10% and then figure out what the designations would be in order for their retirement to go there. Know that retirement designations can be updated whenever you want. So in this case, if we're going to do the retirement going to charity to fulfill that 10%, then we do want Mike and Carol to look at this on an annual basis because they might need to adjust that percentage that they're designating to go to charity. They might want to adjust that annually based on what those assets are doing. Okay. So know that it's not that they'd have to redo their will or they'd have to redo the trust. It's just touching base with the attorney and the financial advisor annually and seeing whether or not they need to either increase or decrease that percentage that of the retirement that's going to charity. You can also here, when we're talking about when one spouse dies, you can have a child from either side be the trustee so that way we're making sure both sides of the family are represented. Talked about how the plan is irrevocable when the first spouse dies. We talked about how you can fund it during life to avoid probate. You can put transfer restrictions on these trusts for the kids, meaning that they're going to get certain amounts when they reach certain ages or when they achieve certain milestones. You can also leave it completely flexible and say they can serve as their own trustee and just pull out for whatever they would need. You can also do interval distributions, so at age 20, 25, 30, 35, whatever you would want there. You can have a different beneficiary for the child for more creditor protection. So what that means is you're going to see each child in there has a trust and they're their own trustee. And that does protect against most creditors. But if you wanted to get maximum protection, then say you're talking about Greg's trust, you may want Peter and Bobby to either serve with Greg as the trustee or to even serve as his own trustee. So it all depends on how much protection you want to give those kids. And then we can include long-term care protection trusts as part of this legacy plan if the clients would ever decide they don't want to keep paying the long-term care premiums for the insurance, or if they'd ever want to protect assets. Usually there's a maximum benefit for long-term care insurance. So if they wanted to ensure that, assets are fully protected, we could always add that into this legacy plan. So again, this one looks a little bit different than Craig and Michelle's, the first one, and then Denny and Denise's is the second one. But I think this accomplishes what they want, and it makes them have a lot of flexibility in their estate plan, which clients are usually looking for. All right, situation number 3. So we do have some younger couples coming in and doing planning, which is great. I'm so happy that they're planning ahead and looking at their future that way. So we have Steve and Amy, they're in their mid-30s. They have 2 children, 10 and 8. So for them, the concerns are if something happens to them, what happens to their children? So in this case, we aren't necessarily looking at trusts for them. You can do a trust if they would want to have restrictions on the children after a certain age, because in Pennsylvania, we can only go up to age 25 in the will. If they wanted restrictions to age 35, then they might have to do a trust. But otherwise, you could do a basic will for this legacy plan. And what we would want to do is we just want to name a guardian, meaning if something happened to both Steve and Amy, where would those kids go? Who would be in charge of their well-being? Where would they live? So they would name a guardian, and then they would name a custodian. And it could be the same person or it can be somebody different. Custodian would be who's in charge of the money. So for example, you might do it to have more people involved, or you might do it because someone's just better with money. So for example, like I said, I have 3 sisters. My sisters might say, well, we're going to name Sam and Jess as, one of them's the guardian, one is the custodian, so that way the kids are going to have 2 people involved in making those decisions. Or they could also say, we're just going to name one person who's going to serve in both of those roles. So either way they decide to do it. This is just a will-based plan. We would want to make sure that they have their beneficiaries updated on their retirement. So again, it might be that it's naming each other and then the children. And then what we do in the will is we do say who is named as the custodian, and that custodian would be for anybody or any assets passing under the will, as well as any non-probate assets, meaning retirement beneficiaries. So if, let's say, in this case, the 8-year-old is named, the 8 and 10-year-old are named as contingent beneficiaries, the will can still say, well, this person is the custodian for those assets. Okay, so we want to make sure everything's jointly titled too, to avoid probate when the first spouse dies. So this is a more basic legacy plan, a more basic estate plan. But again, you always want to go with what makes the most sense in the client's situation. So that's why knowing what assets, knowing how old everybody is, that's always really important. So we would discuss the standby guardianship form. We would discuss the custodial clause that can go all the way up to age 25. We can discuss the guardianship provisions, and then we can, in our office, we do typically recommend including provisions that would allow the executor, the personal representative, to create a trust. And that's just because, say one of the children, you don't anticipate it, but maybe somebody develops special needs or needs a trust to help protect assets. This allows the executor or the personal representative to create it in a situation where it's needed. And we do have a situation where we have that, where person passed away, they didn't anticipate a certain situation for their grandchild, and so now the personal representative is creating a trust to help that grandchild. All right, situation number 4. We're down to our last 2, and we have a little bit over 10 minutes. So situation number 4 would be, and I think this is this situation number 4. I've lost track. But we have John and Carol. They're now retired. John is a physician. Carol is an attorney. They're both in their mid-70s. They have children who are financially stable, and they want to reduce income tax ramifications while they're living and create a lasting charitable legacy. So I picked this one because I'm seeing this more and more. And the reason is because people are wanting to figure out a way to minimize overall death taxes. So when I'm talking death taxes, I'm talking inheritance tax, and I'm talking federal estate tax. So in this case, how do we do that? So the first thing we have to do is take a look at their assets. So this is based on a client that we're currently working on now. So we have a primary residence of $600,000, savings account, checking account. We have some investment accounts. So know that those investment accounts are non-qualified, meaning they're not retirement, 1.5 million. And then we have each spouse has a retirement account. So this estate is over 5 million. So we're still not worried in the sense for federal estate tax planning because the exemption is 12 million per individual. Now, if for any reason this exemption drops, the federal estate exemption would drop, then this might be something where John and Carol need to revisit this estate plan because you can do things in order to make sure we're maximizing that. So, but in this case, let's say we're worried about that charitable planning and that we want to get some income tax deductions if we're able to do that. So we're seeing a shift to more income tax planning and a lot less federal estate tax planning because the exemption is so high, knowing that we do need the ability to be able to pivot if the federal exemption would ever drop. So in this case, everything is jointly titled except for those retirement accounts. And then each of the retirement accounts would have each other as the primary and then probably their kids as the contingent. So let's look at what their legacy plan looks like. So know that in this case, we would look at a charitable remainder unit trust. So, and this is a calculation that I actually ran for this situation that this is based on. So in that case, remember, they have an investment account that has 1.5 million in it. And in this case, I ran the numbers because the financial advisor gave me a copy of their last year's tax returns. And that's why it's so important. If we're asking for a tax return, it's because we're trying to do some sort of planning. And so what we're able to figure out is just based on what their required minimum distributions are coming out of their retirement plan, and based on what their interest and dividends that they get off certain investment accounts, they have enough income that they are not touching that $1.5 million in their investment account. So in that case, what we're able to do is we're talking to them about putting $565,000 into a charitable remainder trust. So how this works is that they set up a trust for a period of 10 years. They'll receive 5% out of the trust annually. And then at the end of those 10 years, anything left in that trust goes to the charity of their choice. So they're fulfilling their charitable intent. But what's really important is that this type of planning would give them an income tax deduction of $339,000. Now, they don't have adjusted gross income of $339,000. They didn't have it in 2020 looking at their taxes, but I'm working with their financial advisor because we're going to convert some of their traditional IRAs. They have these very large IRA funds. And remember, IRAs are subject to inheritance tax as well as income tax when they draw it down. So what we can do is we can convert the traditional IRA to a Roth IRA, and that would normally trigger income tax, because when you take something that you've deferred all the tax in for, up until they actually draw it down, and you convert it to a Roth, you're going to pay all that income tax at once. And so in this case, that's okay. Maybe we want to trigger it. And the reason is because we have that $339,000 worth of income tax deduction that we can use. So know that what we're doing, this is a strategy, a legacy plan that's converting what would normally be subject to multiple taxes, and we're able to reduce it, because when we convert it to a Roth, the Roth, as you draw it down, is not subject to income tax. Not only that amount, so when we look at it being 2.4 million, it's not just as they draw down the 2.4 million, it's the 2.4 million plus any growth that they're able to generate is tax-free when the beneficiary pulls that out. So what we're able to do is we're able to plan not only for John and Carol and their charitable intentions, but we're also able to plan for that next generation. So we're going to convert some of the traditional IRA to a Roth IRA in the same year in which we fund this charitable remainder trust, because we're going to use that deduction that we have to offset the tax that would trigger. Now, know that when I was running the numbers, I looked at the tax return, and this is what I did on Friday afternoon is I sat and ran the numbers, because you want to make sure that you're not either pushing the client into a much higher bracket. So in this case, the client was actually at a 22% tax bracket. So what I did is, it's not a huge jump if they want to max out their 22% bracket, meaning withdraw enough or convert enough from their IRA to Roth IRA and generate that much more income. It's not a whole lot for them to maximize that 22% bracket. It's also not a big jump for them to push it into the next bracket, which is the 24%, because that's only a 2% increase. However, when I was looking at the numbers, I don't want them to jump all the way up to 32%, because that's a 10% tax increase versus only a 2%. So it's kind of finding that line of, can we do this? And then again, you can carry over any deduction that you don't use in that first year for a period of time. So in this case, we're going to do it over a period of years, because we want to make sure we're keeping them below the 24% income tax bracket. And then we aren't triggering the 3.8% Medicare surtax, or what we call the Obama tax there. So, and that would be if their adjusted gross income is over $250,000. So, and they have net investment income in this case, because they have interest and dividends. So it's a lot of fun calculations that we're able to run. I get excited about this type of planning because I feel like these are where you really see the big tax savings. So over a 10-year period, John and Carol are still going to receive between $28,000 and $36,000 out of the trust. Remember, it doesn't go to charity until the 10-year period. You can set up these charitable trusts to wait until John and Carol pass away. It just may mean that their income tax deduction is less. The reason they have such a large one, over $300,000, is because they're doing it in a 10-year period, and that gives them a larger income tax deduction. So this is a lot of fun that we're seeing now with financial advisors who want to minimize the tax and kind of leverage some income tax benefits using a charitable trust. So we were able to accomplish John and Carol's goals of providing for charity and minimizing their tax using this legacy plan. Of course, they're still going to have a will, powers of attorneys, all of that, but this allows them to achieve what they want to do with their legacy plan. Our next monthly virtual seminar is March 24th. Again, it's over the lunchtime hour, and we're going to do myth busting your estate plan. So we're trying to do different ways to present material. So we're going to be looking at some different myths that are out there, especially on the internet as you're looking up things. We're going to talk through them and say what's true, what's not true. You can register by emailing Amy Meek at her email address or calling at the office. You can also do it through our website as well. Amy's going to send out a link for survey and feedback, and know that if you don't necessarily feel like filling out the survey, you can always email Amy and give her your feedback as well. We're always looking forward to that. I just want to thank everybody for being on the call. It's always nice to see you guys and hear from you. I appreciate it. We are going to post this on our YouTube channel after we're done here. So with that being said, I'm going to start recording. Thank you for being here. This is Samantha from the Law Offices of Samantha Wolfe.